mainly because one is an affidavit that comes after the close of the pleadings. And the petitioner has filed this affidavit without permission of the court, contrary to the rules of this court. And therefore, it has to be, or we submit. That is rule.
They're taking the old rules. I was with the old rules, Council.
No, my lady, that is High Court Civil Litigation rules. And
those are the ones.
No, not this one. This is CKE. Okay. I was checking my notes where I have noted it. Yes, my lady. And in particular, my lady, Rule 68.
So, Council, you're not addressing the point in another issue. It's another.
Hence,
the new one.
Yes, this one is the new one because it is something new that that came to light near yesterday. Yes, and being just a point of law, we are entitled to raise it from the bar.
Yes.
Yes, my lady, and we are therefore submitting that, my lady. This.
You could locate that.
I'm saying is Rule 68. In particular, that says no further affidavits may be filed without the permission of the court. Not only that, they filed without the permission of the court, they denied the Crown to react to the said affidavit. If it is filed just in 30 minutes before the close of business, really, we are not given adequate time to react to the said affidavit.
So for you, the timing not necessary. Whether is it proper?
Firstly, it's not proper. It's not proper because it goes against the rules themselves. Not only that, now it even denies the Crown the opportunity to react to the said affidavit. And we submit that it should not be allowed, it has to be expunged and should not form the part of this record. There is also second document, my lady, that is a supplementary. It is styled petitioner supplementary case. My lady, this court had set out the timelines upon which to file the pleadings. And we were directed to file our case latest by the 31st of July 2025. And that was the court order. Now, this supplementary case comes or were filed on the 7th of August 2025. Now, upon even perusal of such case, they address or they invoke new evidence. And if this is allowed, it will be tantamount for the council giving the evidence from the bar. There are no amendments here that they quote what the Commissioner of Police supposed supposed to have said. And those amendments do not appear anywhere in the pleadings, except in this, what is so-called supplementary case. And we submit, my lady, this document also should be expunged, should not form the record of part of the record in these proceedings, and should be disregarded.
Yes, Ntso?
Yes, my lady. That's the.
So the long and the short is that pleadings had already been closed.
Yes, my lady. Yes, my lady.
Yes, Ntso?
Yeah. So, for that, my lady, I don't know if her leadership will make the ruling together with the points that we have placed on paper.
Yes, you can go ahead on the other point, Council, so that when you make your ruling.
Other copies.
Yes. The point that we had initially reached.
Thank you, my lady. And my lady, we have filed our heads that address this issue also. They appear from page 2. The submissions in relation to this issue appear from page 2, paragraph 2. And my lady, it is our submission that the petitioner has not followed the correct procedure in that he is just being remanded for the first time. And he filed an appeal against the remand itself. Now, upon appealing that remand, he says he wants to be released on bail pending that the outcome of that appeal.
Yes.
And by so doing, he places himself in the shoes of a convicted person, whereupon his liberty or continued liberty will depend on the outcome of the appeal. That's what he says. I want to be released on bail pending appeal of my challenge on the remand itself. So that if he is given that bail pending appeal, he says to the court, for me to be free continuously thereafter, even after the determination of the appeal, it will depend on the outcome itself. So that if the outcome of the appeal is that the appeal is dismissed, it means that bail ceases and therefore goes back to prison. So now,
Council, I'm not complicating. It's let me put it this way: the concept of bail pending appeal, does it not presuppose a conviction?
it's the applicant or the petitioner himself that complicates that has complicated it, because he says that. And my lady, I wish to refer the court.
Maybe if we just talk generally of the concept of bail pending appeal, is it proper to have approached this court? For bail pending appeal. Because for me, it presupposes a conviction.
Yes.
And a sentence.
Hence, we are saying he has followed the wrong procedure. Yeah.
Yes,
Yes. And my lady, if her ladyship can check paragraph 3 of the petition that will appear on page 11 of the record. 3.1.
Yes.
He says, your petitioner desires to be released on bail pending his 2 appeals and or criminal trial 0615/2025, so that he may continue with his work. Now, he's the one who complicates this thing, because those appeals differ. The determination of those appeals, the factors therein differ. They can't be combined together. Remember, my lady, in an ordinary bail, the inquiry is investigatory and inquisitorial. Whereas in the appeal, bail pending appeal, is where there is even the onus of proving, because there is the requirement of adducing evidence of exceptional circumstances. So the determination of those procedures are different. And therefore, it cannot be proper to combine the two. In fact, that averment in that paragraph, that is paragraph 3.1, we submit, my lady, goes contrary to the rules regarding the pleadings themselves. It's vague. It's vague. And that rule would be Rule 109 of the High Court Civil Litigations. And we refer to these rules, my lady, although this is a criminal matter, but being a petition, it takes the form of the criminal procedure. I mean, the civil procedure. Hence, the modes and procedures involved would be those under the civil procedure.
The civil litigation rules, don't they just regulate civil applications?
My lady,
that's why I say you are making your life so difficult.
My lady, remember Section 99,
Yes.
I mean Section 101 strictly directs that the bail petition, I mean the bail application must be on petition. That is Criminal Procedure and Evidence Act.
Yes.
And that provision, by so saying, it then directs us to the civil procedure leg of the rules. And this was even clearly stated by this court in the case of just check it first, my lady.
Or maybe he should help you check it.
Yes, my lady. It is Thabo Moshwaba Timotsamai and another versus DPP. Criminal application 0614 of 2018. Delivered by SP Sakwani J, as he then was on the 19th November 2018. Yes. The court says there is no specimen form of a petition described or depicted in the criminal procedure and code. However, the long-standing practice and well-known form is of a petition addressed to the learned Chief Justice and other judges of this court. Such a petition is signed by the legal representation.
You allowed yourself to be distracted.
I tried hard not to, but let's continue. And the court continued to say, such a petition is signed by the legal representative of the petitioner and not accompanied by any annexure other than a certified copy of a warrant of commitment or charge sheet. The second schedule of the High Court Rules 1908 requires that a petition be paid for by way of revenue. The importance of the requirement is that the High Court Rules are referred to in the Criminal Procedure Code as operative rules in criminal procedure process. Hence, we are saying, my lady, this is where we submit the High Court civil litigations are applicable and as the ones that we refer to in terms of determining the correct of procedure that will be followed in this kind of petition.
Yes, please.
Yes, my lady. So, we therefore submit, my lady, the petitioner has followed the wrong procedure by making a bail pending appeal, whereas he ought to have applied for an ordinary bail so that it can be addressed according to its specific factors to be checked. Now, when he combines them together, he makes it difficult for us. What facts or factors should we then address the court on? The factors that are applicable in the bail pending appeal or factors that are applicable in the ordinary bail, which we are saying are not the same. Yes, Madam. And we have quoted, my lady, the case of Malata Diana versus DPP in our haze of argument. It appears on page 3,
Yes.
where the court said it is important to bear in mind that the decision whether or not to grant bail is one entrusted to the trial judge because that is the person best equipped to deal with the issue, having been steeped in the atmosphere of the case. This is why we are saying, now, since he's challenging the proceedings of the magistrate court, of the remand, now if he says, I'm appealing and I want bail pending that appeal, the correct forum, therefore, would be the very same magistrate court that made their decision.
But is it the proper counsel is the petition is charged of sedition?
Yes.
And is it not an offense that is available in the High Court only?
In the matter of ordinary bail, he must come before this court. But when now he talks of bail pending appeal, it's a different thing altogether. Bail pending appeal must be made before the same forum that made a decision that is being complained of. Hence, we are saying he's the one that makes life difficult. Yes, ma'am. And we have addressed this, my lady, through our heads, which I think, my lady, may be not necessary to repeat, assuming or trusting that the court has already read through the heads of argument, because yes, my lady. Otherwise, that's the gist of our argument in relation to the point in limine, because now we also have to go further to demonstrate even the issues of relating to the prospects of success on appeal. For him to succeed on bail pending appeal, he doesn't just end there that, no, I apply for the bail as of a right. Now,
yes, but for now, counsel, it's the issue is whether it's proper to apply for bail
pending appeal. Yes, yes, madam.
We are done on that.
Yeah. That's our submission, madam.
Counsel?
May it please the court, my lady. I'm Advocate Lesinyeho for your petitioner. My lady, I'll be addressing the court on the first two issues. The preliminary points as raised by the Crown. Thank you, my lady. The first point raised by the Crown is that we have filed further proceedings without permission of this court. Well, that is true, my lady. We did not have permission of this court to file the further affidavit. But as you would have it, my lady, we were pressed into a corner. I mean, this matter was remanded as far back as the 4th of July, and bail proceedings were resumed in this very court, to which the Crown was party to such proceedings. We've been exchanging pleadings over time, my lady, and only to come to a point where just a day before the hearing of the bail, the prosecution, in its wisdom, summons the accused to add a new charge, and one of treason for that matter. This was done yesterday. So we had no choice, my lady, because the pleadings and processes in this bail application had already been concluded as at the time. Now, this new process, the so-called affidavit the Crown speaks of, it was basically and mainly to appraise the court of the new position we're in. Court, be aware that we're no longer just dealing with the charge of sedition, although the entirety of the bail proceedings is based upon that. There is now a new charge of treason added yesterday.
You are now hijacking this initial application to introduce new pleadings?
Well,
Yes.
it's not new pleadings per se, my lady. Our position is that this new charge brought in yesterday by the Crown, it doesn't really change our position as far as bail is concerned.
But Councillor, why wouldn't you proceed with the papers filed as they were on sedition, which is what this court is seized with?
We could, my lady, and we had planned to, but the court had to be informed of the new development.
Why didn't you apply?
There was no time. There was no time.
What's indulgence?
Because the prosecution had been quite strategic on the issue. They had all this time, all these months, and yet they did not add this new charge. In fact, just when we were about to, because the matter was set to proceed yesterday, initially, my lady. So on the date that the matter was set to proceed, they bring in to add a new charge. Well, when bail proceedings and all the pleadings were done and dusted, were all concluded, my lady. So you can see, my lady, we had no choice. But
So that you have reached the rules, council, you accept.
no, my lady, we did not breach the rules. We
Yes,
made
by introducing the case, they are new, the supplementary under it.
or I'm being advised by lady that if the court were to take the position that we have in fact breached the rules.
No, I'm not, it's not a determination, council. But I'm saying, are you acceding?
No, my lady, we are not acceding. We're saying this was the only available avenue to your petitioner in the circumstances, my lady, because we could not just proceed to apply for bail on the basis of the initial charges, which is sedition and the other initial charges, and then pretend that there was no new charge added.
But would it make a difference?
My lady?
Would it make a difference if you just proceeded on the papers filed?
Well, technically, my lady, the court would have had bail on the basis of the previous charges, and would that bail or the proceedings of the court would not by any means, I presume, the proceedings of the court would not extend to the new charges added. So to make sure that we do not go back and forth, we just had to appraise the court.
That maybe, for argument's sake, if the court were to run bail,
yes,
then the petitioner could be re-arrested? Probably. That was your fear.
That was our fear, my lady. But I realize that bail, as it is constituted, my lady, it's not so much or entirely dependent on the charges before court, but we felt it would be fraudulent to exclude the court from the knowledge that there was now a new charge. So, my lady, if you go through the new affidavit, it simply appraises the court of what has happened recently, so that the court, in its decision making, is fully aware of all the facts.
Yes, thank you.
Thank you, my lady. And in that case, my lady, it's quite unfair and unreasonable on the part of the Crown to suggest that they were prejudiced or that they were denied any form of opportunity to respond to this affidavit. They gave us no time, my lady. We did with all the time that they had allowed us.
Yes,
Thank you, my lady.
on the second thing, on the bail pending appeal, whether it's proper, you have approved this court.
Thank you, my lady.
It's on a bail pending appeal approach.
Let me leave that to my learned friend.
Thank you, Your Ladyship. And the court would indulge us as we change submissions, my lady.
Yes.
Ladyship, may I be allowed just to add on what my learned friend has said about the additional or otherwise supplementary affidavit? Ladyship, that could have as well been treated in a way that, as we are standing from the bar, we appraise the court of the new developments. What has just happened a mere yesterday. So at the end of the day, whether the court is going to agree with the proposal from the ground that the supplementary affidavit be expunged, but the court is not going to be ignorant of the developments which has just occurred on account of the ground itself.
But counsel, does it make a difference? Because this petition,
Yes,
this
ma'am.
application for bail, is in respect of the initial charge.
The initial charges.
Yes. So why have hits on this other charge when there is no application for bail?
As earlier I said to Madam,
Yes.
were you maybe fearful that your petitioner might, after this court considers this current bail application, then happen not to have been released if, cautiously so, if the court is going to grant bail, then they might come up to say, but still now, you are now faced with the treason charges, so which you haven't applied. So leadership,
Why didn't you find it prudent, counsel, to perhaps have sought a postponement to amend your papers? Because we don't have an application for bail in respect of the other charge.
It wouldn't be proper leadership in this way. Like I have said, leadership, the purpose of this supplementary affidavit is merely to appraise the court. Hence I said, which could have as well been served by us just informing the court from the bar. And the leadership would know, this is by design by the ground. The situation in which we are faced with today or now, relating to this additional or otherwise supplementary affidavit, it was by the design of the ground, which now as the court is sitting, and of course the court sitting on the process of being inquisitorial would have to know the now petitioner the right to object to that approach taken by the ground yesterday, to say, look, I can see there is something that you are actually targeting. I'm to be brought to court on the 12th for remand. But here you are. Prior to that, you are saying I must come so that you add charges. Why couldn't you wait until tomorrow? And they nonetheless said, no, we want to charge you today, add the charges today. So we could foresee the leadership that they want to forestall the outcome of this bail petition. Hence, we had to appraise the court at least. That is true, as far as we can take that issue. But otherwise, the law is very clear. If this court is going to grant bail, whether there are additional charges or not, the petitioner would be released. The petitioner would be released.
But then we agree that the court is ceased with the bail application in respect of the other petition.
Which is bailable here. And the court, the leadership, if we take it in that way, would be mindful of the fact that there are other charges which are not bailable here. In its exercise and wisdom, it's not going to say, since I've granted you bail on sedition, those other charges which are available at the magistrate court, then you will still have to go to the magistrate court and apply for bail. That is not how the law operates. As we are saying, if this court grants bail, insofar as those charges, how much they may be, the court would have granted bail to the petitioner. So, her leadership, in essence, we are still emphasizing this issue of supplementary affidavit was merely to appraise the court. It was not meant to bring anything that this court is not going to determine, but at least in the mind of the court, it should know that, okay, ground, you pressed yesterday to add additional charges. Not even prefer new charges, they have actually added more charges.
Yes,
Thank you, Chief. Now, on the issue of impropriety or otherwise, whether this application is properly before this honor court,
yes.
a leadership would realize that ground decided to to have a cherry-picking approach when dealing with this matter. Allegedly, your petitioner, when he makes a petition application, I'll start at page 9 of the record. That's where your petitioner clearly states as to why is he before court. I've been remanded with the charges for contravening section 76(2)(b, read with 5A and other. It's a fact. Crown decided not to tell you that, or even to bring the court's attention to that. Paragraph 2.2. Now, as inquisitorial this court may be, the court ought to know what is actually surrounding this petitioner insofar as these matters are concerned.
But was it not prudent just to apply for bail, not for bail pending appeal? Because it's a different concept.
I'm coming to that headship as to answer it. I'm coming to answer that, but I was trying to at least have the introduction.
Yes.
Right. But let me outrightly say, headship, this is the normal bail application. It is not bail pending appeal.
Your para 3?
Then, headship, before I get to para 3, let me go at Serati 2.2. Para 2.2. That's why your petitioner tells the court that as of the date your petitioner was so charged as aforesaid, your petitioner was awaiting a hearing of his appeal against the decision of the Constitutional Court filed in the Court of Appeal under case number C of A, civil number 32 of 205, which he sought for the said court to interdict the Commissioner of Police and Government of Lesotho and South Africa for arresting him for failing to filing a petition in the United Nations for the return of Basutoland land. I pass the headship to 2.3. Your petitioner also filed an appeal against the decision of the Honorable Magistrate Litsika under Criminal A 0013 against the decision under charges which were unlawful for inter alia. The reason that they were not instructed by the DP, the narration of why they were, he is regarding them, yes. 2.5.
Why? Because your para 3, it gives your prayers.
It is not a prayer per se.
It says your petitioner humbly requests to be admitted to bail. Your petitioner desires to be released on the pending these 2 appeals.
And or the criminal trial. And or the criminal trial. And hence the leadership, if he had allowed me to go through these paragraphs which I was reading,
Okay.
she's going to appreciate her leadership as to why it was imperative upon the petitioner at least to give this narration of the circumstances surrounding him.
But Council, why didn't you apply for ordinary bail?
Leadership, I respond once again that this is an application for ordinary bail.
Okay, also as far as you're concerned, it's an application for
Ordinary bail. It is not a bail pending appeal. Yes.
Yes.
Because your petitioner was simply telling this court that there are these pending matters, but as of effect, in terms of Annexure A, your petitioner has been remanded
Yes.
in custody for having contravened or otherwise have been charged with the charges which are available before this court.
Yes.
So we are not going to be clouded by a mere assertion that your petitioner desires to be released on bail pending his 2 appeals and or criminal trial. And he mentions it specifically, which is what? The criminal trial under which the charges which are available before this court relay. So that's the cherry picking we are talking about. Ground decided to cloud itself or misdirect itself to say we are applying for bail pending appeal, when even the circumstances of this application are clear that he is applying for a normal bail application and the charges which are not bailable before the magistrate court. Now they say, Your Ladyship, hence I said my lady might find us, when we address this issue, touching on the merits of this application. I will try to refrain myself, but at least respond to what they have said. They are saying the rightful procedure would have been for us to apply for bail before the magistrate court. Hence, the jurisdiction of this honorable court is wanting. That is a submission. They say so. They talk about jurisdiction of this court because they said at the end the court might find itself having to refer the merits of this case to another forum. Yes. I don't know what procedure ground is actually suggesting to this honorable court. The court of law has said you are charged with charges which you will have to ask for bail before the High Court. The record reflects it.
Yes,
Then how then was he to now apply again to the court for the bail, the very same court? How would he apply for bail? So that is why we are saying they have just decided, and surely intentionally, to misdirect themselves that we are applying for bail pending appeal, when they actually read the papers, that these papers are clear that your petitioner is applying for bail. So,
it's because of the words that you used. You used in paragraph.
Why only that sentence, Ladyship?
That your petitioner desires to be released on bail pending his two appeals.
And all.
And all criminal trial, this one.
Yes.
That is, yes.
Yes. So
that has been brought on appeal.
No. This criminal trial.
615.
Yes.
2025.
Yes. That is where he's been charged with section contravening section 76(2)(b), which is bailable here.
Yes, but I'm saying this is the matter that's been brought on appeal here in another matter that is pending before this court. And
relative for her to appreciate what has been brought before court on appeal is the refusal to refer the constitutional questions.
But
not that he shouldn't be charged.
But I'm saying, does it emanate from criminal trial 615 of 2025?
The appeal.
The other appeal that is pending.
Yes. It emanates there. But that doesn't mean he cannot still apply for normal bail, regard being to the sections, or otherwise the section which he stands to be charged with.
What is the status of the appeal that is pending? What is the status of the case?
Well, not yet set for hearing. I think even the all the necessaries haven't yet been done, being the heads and the likes. Yes. So we cannot just confine ourselves to this assertion that your petitioner is desirous of being admitted to bail pending his two appeals, and we leave aside and all. Because this and all is now going to be determined according to the factors in this bail application. Is he advancing bail pending appeal, or is he advancing ordinary bail?
Let's speak English here. Can we revisit 3.1?
Yes, Sir Richie.
Let's leave these two appeals.
Yes.
And then your petitioner desires to be released on bail pending criminal trial. CRIT 615. So the main problem is with the concept of bail pending appeal.
Leadership, I don't appreciate or I don't understand how it is posing any difficulty
Because it's a concept.
when it is clear that there are there are two appeals filed, which of course haven't dealt with conviction.
Yes.
Those two appeals do not, or they are not appeals relating to the conviction. And the principles of bail pending appeal, we know, that they are where bail has been denied or otherwise conviction has been acquired. Where the petitioner has been convicted, he can apply for bail pending appeal. But here there is no conviction. Hence I'm saying.
That's why the Crown is saying it's improper. You ought to have just applied for bail.
And we are saying we have done so. This application is bail proper, not bail pending appeal.
Yes.
As emphasized by the law, that you will apply for bail pending appeal where you have been convicted.
Yes.
Hence, leadership were drawing the attention of the court that even if we were to try to separate the sentence, and we read it in this manner, trying to separate this sentence, your petitioner is desirous to be released on bail pending, say we leave aside two appeals.
Yes.
Then we say pending criminal trial 0615-2025. That will be bail proper. That will be bail proper.
No, it's noted, Council.
Thank you, Leadership. And Leadership, Ground wanted to allude to the fact that insofar as these proceedings are concerned, the civil litigation rules are applicable per the case they read. Leadership will submit with respect. That case which Madam Friend read dealt with the repealed rules.
Yes.
The repealed rules, which had a specific rule relating to revenue, which is what actually the CJ wanted to introduce insofar as criminal applications are concerned. But it did not address, or even in their submission, they never said, as a general principle, the civil procedure rules, which in our jurisdiction we refer them now as High Court civil litigation rules, apply. They apply even to criminal applications. That case doesn't say so. Because it was actually addressing the specific rule in 1980 rules.
Yes.
That because of that rule, that presupposes that we can still apply those rules insofar as criminal matters are concerned, insofar as revenue. But it was not a general principle towards procedure to be adopted insofar as criminal applications are concerned. So it will be misleading to say the civil litigation rules also apply to criminal applications. In as much as it is a petition, but it's a criminal application.
Yes.
Yes. So, Leadership, at the end of the day, as we have said, these proceedings are properly before this honorable court. Your petitioner is applying for bail insofar as, or on account of the charges which are available before this honorable court. So this point, the leadership which has been taken by the ground, it is our submission that it be dismissed and we get to the bail proper, the merits of this application. Unless there are questions, the leadership, that will be our response.
Also, my lady,
You want to add?
yes, my lady, just a little bit. I'd like to refer my lady to page 22 of the petition. Page 22 and 23. My lady, when you look at the body of the petition and the prayers therein, they speak to bail, not bail pending appeal. As my learned friend has said, I refer the court to paragraph 6.1, and the heading is, in the event of being granted bail, not bail pending appeal.
But these are conditions.
Yes,
These are
ma'am.
bail conditions.
And if
That are not prayers.
if we were applying for bail pending appeal, we would refer to different conditions altogether. So this is just to drive the point home that our intention was never to apply for bail pending appeal, but bail proper or ordinary bail. It says not to abscond, but to stand trial and abide judgment of the court. This is a condition ordinary to ordinary bail. And every other, my lady, not to hamper police investigations, not to interfere with crown witnesses, not to prejudice the administration of justice in any manner whatsoever. And for the prayers themselves are even clearer, my lady, because I think the idea here is to emphasize the tried principle for the court to consider substance over form. Substance over form, my lady. There is nothing about this petition that even suggests that we are playing for bail pending appeal. However, it was always our intention to alert the court that there were these pending appeals. Now, I refer to 8.3, my lady. 8.3 says that, this is a prayer, that he attends his remands.
Counsel, these are conditions for bail.
Exactly.
When you go into the conditions.
Exactly.
You know, you have made your point that if it were bail pending appeal, it wouldn't have been couched in this manner.
My
So
point
I
is
have captured that point.
Thank you, my lady. That would be all.
Anything in reply, Counsel?
Yes, my lady. In reply, my lady. And you see, the reason that we are saying this supplementary affidavit should be expunged. My learned friend says they introduced it to bring to the attention of the court of the new developments, and he went further to say, when the court, assuming the court grants bail in this application, then would mean he would be simultaneously be granted bail even in the new charge. That is, he says that is added.
They didn't say that.
No, he said that.
It was more for information.
But he says, should the court grant the bail in these proceedings, he is therefore even granted bail in respect of this. Yes, hence we are saying the more reason this affidavit should be expanded, because they want to break the bail with the back door, bail application with the back door, which the petition is still at liberty to apply for.
Yes.
Yes, madam. And therefore, we still submit that this supplementary affidavit should not be allowed. And it is submitted that the bail, as we submitted earlier, that if he talks about bail pending appeal, we want to go to the magistrate. We did not refer to the ordinary bail. Yes, for ordinary bail, for sedition, he has to come before the High Court.
Yes.
But he chooses the path of bail pending appeal. Therefore, this is one direction that takes him back before the court that made the decision or that deliberated on the 3-month proceedings.
He says, the council are saying that was not the intention.
But
That the court shouldn't take form over substance.
But then, the issue of bail pending appeal doesn't even start with paragraph 3.1 alone. This petition was brought on an agent basis. It was accompanied by a certificate of agency as attested by one of their counsel, Advocate Burana Haboketis Konyala. It appears from page 5 of the record, my lady, and I wish to refer the court to page 7, paragraph 2.6.
Why should you take us to agency?
My lady?
Why should you take us to the
No.
application for agency?
It accompanies the petition itself.
Yes, but this matter was not heard as a. I mean, it was just heard expeditious because bail is urgent by its nature. It's not an urgent bail.
It is relevant, my lady, because now the submission of the petitioner's counsel is that it is the ground that confuses itself whether this is a bail pending appeal or bail, ordinary bail. Now, paragraph 4.6.
Yeah, Your Ladyship. The approach and style I wholeheartedly dislike. To object when submissions are being made. Your Ladyship, my learned friend should recall that he's at the reply stage. This issue, which he now wishes the court to have attention, was never raised in their objection or otherwise in their point. We did not even touch it ourselves.
What?
The issue of the certificate of agency. Him referring to the certificate of agency.
No, was he not just referring to it by way of background?
Background. He is.
That's why I was trying to say to him, no, let's not go back there to the agency.
He doesn't even have to have any background. He has to reply to what we have said, because we answered their point. So he cannot touch on something new. That is the basic principle, Ladyship. Yes.
Objection sustained. Counsel, can you reply to what they said? Because you already looked at the Crown's submissions on the point in limine placed and on the failure to comply with the rules.
I'm afraid, my lady.
For new affidavits.
I'm afraid, my lady, the court has ruled that the objection sustained before I reply to the objection. Yes, please. Yes, sir.
Yes.
My lady, we submit, we are still in line with the reply. The submission has been made here that the Crown is the Crown that confuses itself, and the term they even say deliberately by saying this is by confusing this with bail pending appeal or ordinary bail. Now we have the right to reply. Now I'm referring to their record where they say this is bail pending appeal. I think we are still within our rights to reply.
Okay,
I'm simply referring to the court where they say this is bail pending appeal.
so it was not only referred to in para 3?
Yes. And
Where else?
paragraph 2.6 of the certificate of agency. The last sentence there. Advocate Burana says, therefore, your petitioner stands to be released on bail pending his 2 appeals filed in the High Court of Lesotho in criminal appeal number 13 of 2025 and the other filed in the Court of Appeal. So it doesn't only appear in the paragraph.
But counsel, that point is taken. But then I'm saying the application for the certificate of agency. That is why I was saying we shouldn't go to it. because we didn't entertain agency. Agency was never argued. So that is why I'm saying let's not go to the agency, the certificate of agency. Because it was never an issue. Agency was never an issue.
But
Because normally what would happen, you would have to determine agency first. But then it never became an issue. So the court never had to apply its mind to the agency or otherwise of this bail application. So no, I appreciate your point, counsel, that as far as the Crown is concerned, it's a bail pending appeal.
Per the petitioner's amendments, not our own making. Yes, Madam. And now, there is this submission that the Bozaman case is not applicable here.
Yes.
We submit, my lady. Bozaman case clearly, as a general rule, stated that the operational rules, as CPNE does not set out the procedure for filing and or the form of the petition for bail. Now the operational rule would be High Court rules. Now, the current High Court rules, although at that time it was referring to the old 1980 rules, we submit. If they are being repealed, therefore we will go along with the new rules, and therefore.
Is there still a provision that is that?
Yes, the provisions relating to the applications are still the same as in the old rules regarding the form and format of the applications, the set of the pleadings, that being the petition, then answering affidavit, the reply. That's the close of the pleadings.
Yes.
Yes, hence we are saying it is applicable, and therefore they ought to have complied with format and relating to the requirements of the pleadings, that they should be or they should not be unambiguous, like saying I'm applying bail for pending appeal and or pending trial. What's that? So we submit, my lady, this application does not conform to the rules of procedure of this honorable court. We so submit, my lady.
Yes, counsel. We are not in a position to make a ruling now, because as you might appreciate, there's a lot that has been said, so the court has to apply its mind to the submissions made, and again, we are on duty. So we actually have a matter now at 11 proceeding. So, but then we'll try to make a ruling as soon as possible, and you'll hear from the judge's clerk.
As a process.
Yes, the court shall adjourn.
That.